Hello, everyone. Good morning, Europe. Good afternoon, Southeast Asia and China. And I'm Marta, and I will be today moderator for the webinar. I am the IPR Business Advisor at the Southeast Asia IPR SME Help Desk, and it's my pleasure to welcome all of you. Let me guide you through the function of the platform, because I think a nice overview of the platform will be nice. First of all, you can see on your right there is the control panel. The important part of this control panel is the question and chat, because with that you can interact with our speaker live, and you can ask all the questions you want us to answer. If for whatever reason your question has not been answered, you can drop us an email, but you most likely will receive an email from us answering your question in the upcoming days. We are very happy to have you interacting with the speakers, so please feel free to ask anything. That's as for the platform. Let me discuss briefly the services that the IPR Help Desk brought to you. We have 3 help desks with 3 different geographic coverage: Southeast Asia, China, and Latin America. We all, with 3 of us, offer the same kind of services. You can find on our website the guidelines and the fact sheet regarding the regions, but you can also attend our webinars as you are doing today, but also you can attend our training in person if you end up either in the region or in Europe. So have a look on the news on our website, which is always updated. And finally, we welcome all the questions via email, phone, and whatever other medium you think is appropriate. So for today, we are going to have a very interesting discussion about the protection of trademark, especially focusing on the Madrid System. And we will have 2 amazing speakers, Mr. Simon Cheetham and Ellie Salis, who will represent the first one, the Southeast Asia and China point of view, and the second one, the Latin America. Just to give you an idea, Mr. Cheetham is the team leader of the China IPR SME Help Desk, an expert for our Southeast Asia Help Desk. Is a China IPR enforcement expert with over 30 years of experience in commercial investigation, due diligence, and IPR enforcement in China and internationally. He is a managing director of Irani's International Ltd, and a firm he founded to capitalize on his extensive experience of international investigation, loss prevention, and enforcement work. He managed and directed the operation of the company from Europe to the Far East. He has lectured frequently around the world on security issues and IPR, and has written articles and papers on a variety of related topics, including a chapter in intellectual property law and practice in the People's Republic of China, published by Kulo International. As for Mr. Salis is a patent attorney at Design IP in Alicante, and focused on intellectual property, in particular with the protection, prosecution, and enforcement regarding trademark, patents, design, and copyright. He has graduated from the University of Litoral, Santa Fe in Argentina, and he has a master's degree on IP from the University of Alicante. He represents international and medium-sized companies in proceeding before National Office and of Patents and Trademarks. He also has an extensive experience in managing and coordinating the prosecution and enforcement of IP matters across the Europe and Latin America regions. Ellie is author of several publications on IP matters and lectures at different universities in Europe and Latin America. He also provides a consulting service to the world, to the WIPO. So, this being said, is now your turn as an attendee to answer our poll question. So this is addressed to all the attendees. The question is, have you already registered your trademark in more than one country using the Madrid system? So the possibility of answer is yes, no, but considering to do, and D, registering in multiple countries but not using the Madrid system. So please, the pool is now open, and it will stay open for around 1 minute, and then we will show and comment the results. Okay, you have the last, let's say, 10 seconds to answer. And now we close the poll and we show the results. So as we can see, we have a small majority of no's, and yes and no, but considering to do an equal share, which is interesting. And then there is the D. So it was worth to put because someone said that. And now I would like to hear from Ellie and Simon, if you have any comment on these results.
Well, I hope that after our talk, people are more willing to use the Madrid system.
So you want to cancel the D, basically. Simon, what's your opinion?
Yeah, it's very interesting to see these results. I think for those who've already registered in more than one country, then that's great, irrespective of which way they are doing it. They still deserve some congratulations for doing that, and I hope this webinar will now boost their efforts. And for those who have not yet done so, or haven't used the Madrid system, well, hopefully this webinar will help you decide your next steps.
Okay, thank you. And I think now we are ready to start with the presentation itself. So it's still up to you, Simon, and I leave you the floor. And
thank you.
We talk soon.
Thank you, Marta. So perhaps the first issue to address is whether registering your trademark is going to be useful and how important it is. So to answer that, here are a few key points about the importance of trademarks. They are really an essential part of the identity of goods and services. They help deliver brand recognition. For example, they distinguish your company from the competition. They also help to build trust, reputation, and goodwill for your company, as well as play an important role in marketing and advertising. And in this way, your brand becomes an important asset, which creates value in your business. I think we all instantly recognize well-known brands, and you may be surprised at how advanced businesses are in China and Southeast Asia in recognizing the value in registering trademarks. There are financing schemes available in places like Singapore and Malaysia to enable businesses to monetize their trademarks and other intellectual property for business growth and expansion. And it's increasingly common for local businesses to look outside China and the Southeast Asia region for inspiration, a trend that can easily lead to imitation of products branded or developed in other markets. Many trademark owners are confronted with this reality too late, and only when their branding has been already copied or registered to local parties. First come, first serve is the theme you should really apply, meaning the first to apply to register a trademark is usually the one who will successfully register and own it. Ideally, start your trademark application before you start doing business in or with these markets, and bear in mind the need to register in each jurisdiction. So when you're looking at China, think about the need to also register in Hong Kong and Taiwan. And when looking in Southeast Asia, for example, at Thailand, think also about Malaysia, Indonesia, Singapore, and so on. In fact, you can't look at one market in isolation. Goods and information flow quickly from country to country. In Southeast Asia, there is AFTA, the ASEAN Free Trade Area, a trade bloc agreement by the Association of Southeast Asian Nations, supporting local trade and manufacturing in all ASEAN countries. It stands as one of the largest and most important free trade areas in the world. So if you sell your brand of products or services in one country, be prepared in case competitors jump in and register something similar next door. So let's turn to trademark protection in China, which is the next slide.
Sorry, I have to interrupt for a second because we are having some issue with the Wi-Fi. So just allows us 1 second to change the screen. So
Okay.
sorry for the interruption, but it's out of our control. I'm sorry. Just 1 second.
Perhaps while you're doing that, Marta, shall I continue? Oh, here we are. I can see the trademark protection in China slide.
Yes.
Okay, great.
Please,
so
go ahead.
So I will continue. So China is a first to file jurisdiction, meaning it's important to be the first to apply to register your trademark there to avoid the danger of losing the right to use your brand. However, once you have filed an application to register, you cannot be overtaken by someone who subsequently tries to register your brand in the same class and subclasses. There is an increase in the number of trademark applications in China. And a certain proportion of those filings are in bad faith. So while regulations in China have been modified to limit the amount of trademark applications a company can file, there is a loophole to this regulation. The amount of companies that a single person can register is not limited. So this is sometimes used as a way of filing multiple applications through different countries by individuals, even though they belong to a single person. And it may even result in tax cuts to the company's owner. China uses the NIS classification, as in Europe, but the Chinese version of the NIS classification differs. In China, product and service classes are divided into subclasses. You need to be aware, as this may cause problems. And what does this mean? Well, during trademark examination, the China Trademark Office does not assess the similarity of goods or services on a case-by-case basis. Instead, China operates a subclass system within each class as a convenient shortcut to determine the similarity of goods and services. Items classified into the same subclass are usually considered similar, while items classified into different subclasses are usually deemed dissimilar despite being in the same overall class. The number of subclasses within different classes varies greatly. There are small classes that contain fewer than 5 subclasses through to large classes where there are approximately 20 subclasses, and in the biggest case, 54 subclasses. So, as a foreign applicant, you might choose a class heading as the trademark specification and assume the whole class is therefore covered, but this is not true in China in practice. Firstly, class headings are often not acceptable and usually have to be amended to reflect specific goods and services within that class. And secondly, even if a class heading is accepted, only the items specifically itemized in the text heading itself are covered. So for example, the applicant might register a trademark on clothing, footwear, headgear, and the heading for class 25, and therefore assume that all 13 subclasses that comprise the class are also covered. In fact, only those subclasses that relate specifically to clothing, footwear, headgear are actually covered. It does not cover the other subclasses such as socks and related items, and gloves and related items, on ties and scarves, belts, and so on. This means that a third party can still register the same trademark on those uncovered subclasses because goods in those subclasses are considered dissimilar to clothing, footwear, headgear during trademark examination. So in other words, the whole class is not covered. So when you're thinking about your trademark registration in China, do consider how it will be used in the country where very few people speak English. So think about putting your trademark into Chinese. So taking a look now at the trademark protection in Southeast Asia. Countries in Southeast Asia also use a first to file system. You need to register in each country where you want to protect your trademark. It is best to carry out searches in each country where you want to register. This sometimes gets forgotten when international applications are made, but it's important because a country may refuse the application for local reasons. The Madrid Protocol is administered by WIPO in Switzerland, and you can use the global brand database on the WIPO website to carry out searches. But please note, while you can search simultaneously in different countries using the global brand database, it's advisable to search separately because simultaneous searches will tend to bring up registrations in all those countries and may miss some similar marks registered in just one or two locations. Be prepared that the time you have to deal with the application refusals or amendments can vary a lot. In some countries, the deadline for office actions, that's the time period given for a trademark applicant to reply to an application refusal or to amend the application in some way, can be short. In Thailand, it's 60 days. In Vietnam, for example, it's 3 months. This does not necessarily give much time, especially if you need to appoint a local agent to handle the matter. And as in China, bear in mind the registration of a trademark in original Roman characters does not automatically protect the trademark against the use or registration of the same or a similar trademark written in local characters or scripts used in certain countries in Southeast Asia, such as Tamil, Thai, Lao, Burmese, or Khmer. So do consider registering a version of your trademark in the local language in the country of interest. Also consider that some sort of local name will be adopted by local consumers and not necessarily with the right connotations or image that you would wish to convey. So here are a few points then for Southeast Asia. How does this then compare with Latin America? Well, for that, I'll hand over to Ellie.
Thank you, Simon. First of all, we need to clarify that the Madrid system is not implemented in most Latin American countries. Just Cuba, Colombia, Mexico, and most recently Brazil are members of the system. But this situation is expected to change in the near future, or at least in the future. Therefore, EU companies that want to have protection in Latin American countries may be interested in registering trademarks through the Madrid systems on the current members, that is Colombia, Cuba, Brazil, and Mexico, and hopefully extend the protection to further members once these members enter into the system. I think that we already know that registering in every country is an almost impossible task, specifically if you are doing business online. It is difficult to know ahead of time where the people that shop through your website come from. Having said that, there are ways to register your trademark internationally without having to go through the process of registering with individual countries. For example, if you are planning to sell your products in Argentina, Uruguay, Peru, and Brazil, maybe it has no sense to use the Madrid system because Brazil is the only member of the system, and in the other countries you have to file national applications. But if your business plan also covers Colombia and Mexico, for example, then you have to consider using the system. Now we are going to be talking about how to manage your trademark portfolio through the Madrid system. If your company wishes to register your trademark abroad, a choice must be made regarding the best way to do it. There are several ways in which you can register your trademark. For example, the national route, that means to file trademark application or applications with the IP office of each country in which you want protection, for example, China, Thailand, Bolivia, or Paraguay. The regional route, that is applied through a regional trademark registration system with effect in all member states. For example, the Benelux trademark office, the WIPO here in Europe, and for African countries, we have the WAPI and the ARIPO system. And the third option is the international route, that is filing through the Madrid system. This system allows your company to have a trademark protected in several countries with just one trademark application. And this is very important, one trademark application for several countries. The international route through the Madrid system may be the preferred option when you want to seek protection in multiple markets, particularly if these are in different regions, or if you want flexibility to add new markets as your export plans develop through a subsequent designation that is allowed in the Madrid system, or if you have a limited budget and or time to spend on registration and management of your trademarks. The Madrid system is also convenient due to the following reasons. You have access to a centralized filing and management procedure. We are going to see this later. And you just have to file one application in one language and paying only one set of fees for protection in multiple markets. The Madrid system is also cost-effective because you only file an international application which is the equivalent of a bundle of national applications, saving time and money, and you avoid paying for translations into multiple languages or working through the administrative procedures of multiple IP offices. Next, please. The Madrid system, contrary to the European trademark, is a closed system. What does it mean? To be entitled to use the Madrid system, the applicant must be a national of a member state or has an address in a member state or have a real and effective industrial or commercial establishment in a contracted party for the Madrid system. We have to point out that all European companies fulfill this requirement. But if your company, for example, incorporated in France, has a subsidiary in Peru, this branch cannot use the international trademark because Peru is not member of the system. Another requirement is that the applicant needs to have registered or filed an application. It's what we call a basic mark in the IP office of the applicant's entitlement. This is what we call the office of origin. And finally, the international application must be sent by WIPO through the office of origin. Regarding the last two issues, there are three different stages. Stage one, before you can file an international application, you need to have already registered or have filed an application in your home IP office. The registration or application, as I said, is known as the basic mark. You then need to submit your international applications through this same IP office, which will certify and forward it to WIPO. For example, if you're a Spanish company, you can use your earlier Spanish or European trademark. Stage two, WIPO only conducts a formal examination of your international applications. Once approved, your mark is recorded in the international register and published in a bulletin. WIPO will then send you a certificate of international registration and will notify the IP offices in all the countries where you wish to have your mark protected. Be aware that if you receive your certificate of registration but the trademark is then refused in all the countries designated, of course, you don't have an international trademark, although you have in your records a certificate of registration. And stage 3, the IP offices of the countries where you want to protect your mark will make a decision within the applicable time limit, could be 12 or 12 months, depending on the country, in accordance with their laws. WIPO will record the decisions of the IP offices in the international registrations and then notify to you. And then in the next slides, we are going to see how to deal with these provisional refusals. Next, please. Now, I want to give you some tips if you are planning to use the Madrid system. Firstly, and I think that Simon was talking about this, before filing an international application, you should search to find out if identical or similar marks already exist or are pending in your target markets. In this sense, you can use public databases or, for example, a trademark view, which is a tool developed by WIPO here in Alicante, and which is very, very useful. Discovering an identical or similar mark prior to filing may be preferable to find it out later. Secondly, at the WIPO's website, you can find a guide which explains you more about the process, including your eligibility to use the Madrid system, how to complete your application form, the required fees. You have also a calculator for the fees, and how to track the status of your application as it moves through the examination process. When submitting your international application, indicating an email address enrolls you to WIPO's e-notification service. This means that you will receive all notices or documents concerning your international application or registration via email. Also, the tool Madrid Monitor provides the status in real time of an international application being processed by WIPO and the status of your international registrations in designated national offices. This allows you to see what is happening to your mark at any time. Next, please. Well, as you can see, there are several advantages of this system. After filing national or registration trademark application, the trademark owner has to file only one international trademark application in one language, paying one fee with its national or regional trademark office, instead of filing separately in the trademark offices of the different contracting parties in different languages and paying a separate fee for each filing. Changes subsequent to registration, such as a change in the name or address of the owner, which are quite common, or a change total or partially in the ownership, or because you have sold part of your trademark to a third party, or a limitation of the list of goods and or services may be recorded with effect for several designated countries, contracting parties, through a single simple procedural step and the payment of a single fee. And most important, there is only one renewal date. That means that at the time of the renewal, that is 10 years after filing the application, you have to renew the trademark for all designated countries at WIPO. Also, the streamlining of this process results in significant savings at the final stage of prosecution. And finally, and this is the most problematic issue in regarding the international system, if the home application or registration falls or is limited, which would result in a central attack on the international registrations, which I will explain in the next slide. The Madrid Protocol provides for a limit period, 3 months, during which an international registration may be transformed into new national or regional applications in the designated contracting parties. Next, please. Well, regarding the disadvantages of the systems, as I said before, one of the challenging characteristics of the Madrid Protocol is the dependency of the international registration on the home application or registration. This can lead to a problem known as central attack. That means that if the home application registration is denied or cancelled during the 5 years following the international registration date, the international registration is also affected. On the contrary, once the international registration has been in effect for 5 years, it becomes independent from the basic registration. At that point, the possible cancellation of the basic application or registration no longer has any effect on the international registration. And finally, if problems arise during examination or following publication of an international trademark application in a contracting party, for example, observations issued by the IP office or oppositions filed by a third party against our trademarks, this may reduce or eliminate savings of professional fees if assistance from a local trademark agent is required. I think that is your turn now, Simon.
Thank you, Eli. That comprehensively outlines some of the great advantages to the Madrid system. Perhaps I can just add that really the greater the number of countries included in a registration, I think the more cost effective the Madrid system becomes. But conversely, if you're looking to register only in 1 or 2 countries, then it can be more cost effective to register nationally in those countries. And also consider how urgent the registration is. Under the Madrid system, registrations are completed within a fixed deadline for registration or refusal, which can be 12 or typically 18 months. Yet if you apply nationally, the process can be much faster. In Cambodia, for example, the process takes 6 to 8 months if you apply nationally, and that's nearly 3 times faster than the Madrid system. But the other side of the coin is true as well. For national registrations, the procedure can take longer. In Southeast Asia and Indonesia, registration procedure can take as long as 36 or even 42 months. Also, the Madrid Protocol doesn't apply everywhere. If you're using the system to register in China, be aware that the registration does not extend to Hong Kong or Taiwan. And both are not part of the Madrid Protocol. And similarly, in Southeast Asia, Myanmar is not a party to the Madrid Protocol. Eli has already mentioned that not every country in Latin America has joined the Madrid system. We've touched upon the issue of China's subclasses, but there's also the issue of obtaining a China trademark registration certificate. For China, normally no pre-application screening is performed, and there's no chance to revise an application when you use the Madrid system. But that step is available if you register via a trademark agent directly in China. Even when the trademark has been officially registered in China through the Madrid system, you will only receive a WIPO certificate stating the company's rights under Chinese trademark law. But in business reality and for legal applications, the Chinese authorities and Chinese businesses frequently do not acknowledge the certificate provided by WIPO, and instead they will require a copy of a certificate issued by the Chinese Trademark Office. The international registration, as Eli has mentioned, is dependent for 5 years on your original registration remaining in force during this period. So if your original trademark is contested in any way, then the international application will be affected in the same way. Your trademark can also be opposed, as we've heard, in any of the designated countries. But if successful, such an opposition will only affect the international registration in that country. Bear in mind that if somebody opposes your mark, as Ellie has alluded to, and you withdraw or lose your challenge to an opposition, you may have to pay towards the other person's costs. And any costs incurred are set according to the law of the national offices in the designated countries. So you may wish to seek professional advice if your international application is opposed. So having discussed the advantages and disadvantages, let's take a look at a couple of case studies to highlight issues that can actually arise with trademarks in other countries. Now, this case study looks at the trademark registration in Thailand and deals with a trademark registered in the EU on a variety of products. And you can see the copy of the character, a cartoon representing a urinating boy. And this was registered in classes 9 for compact disc holders, class 16 for printed matter, 18 for leather bags, 21 for household or kitchen utensils, and 25 for clothing in Europe. But in Thailand, the trademark office held that the device of a cartoon presenting a urinating boy is not polite and contrary to morality, and thereby not registerable under the Trademark Act there. So the ironic issue perhaps about this particular registration is the owner of that trademark application was in fact a Thailand company called Propagandist Company Limited. So the takeaway point is what is acceptable for registration in one jurisdiction is not necessarily registrable somewhere else. And our second case study, this time for China, deals with the language issue. In this study, a Chinese businessman named Mr. Zhu acted against a China sales company of the footwear company called New Balance, a large company, because they were using the trademark Xin Bai Lun. Xin in Chinese means new, while Bai Lun is the phonetic translation of balance. And Mr. Zhu applied for the trademark in 2004, and it was issued to him in 2008. And since that time, he had been selling his own footwear products under that trademark. The New Balance is an old company founded back in 1906, and it tried to fight that trademark registration, stating that they'd been using the trademark even before Mr. Zhu filed. But the China Trademark Office was not won over by New Balance's arguments, and nor were the courts in Guangdong. So if we go on to the next slide, we can see what happened. In 2017, the Guangzhou Municipal Intermediate People's Court ruled for Mr. Zhu, and they awarded him 98 million renminbi in damages, which was judged to be half New Balance's profits earned during its time of infringement. Well, New Balance appealed to the Guangdong Higher People's Court. The appeal was dismissed, but they did reduce compensation to 5 million renminbi, which was Mr. Zhu's actual damages. But the significant point was that the court also rejected New Balance's argument that Xin Bai Lun was a translation of the company name, because a proper translation for New Balance should have been Xin for new, Ping Heng, which is the actual translation for balance. And this was also the name of New Balance's affiliate, Xin Ping Heng Aesthetic Shoe Company. And the court pointed out that New Balance had previously used the name New Ba Lun, which is the phonetic translation of New Balance. So in the end, New Balance's argument that Xin Bai Lun is the company name in Mandarin was simply not supported. And I think this case goes to show the care that needs to be taken when choosing what trademark to use. And now I'll hand over to Ellie for a case study in Latin America.
Thank you again, Simon. Very shortly, I want to explain a real case involving a Spanish cook who has a very good idea for a new food product. He wants to sell this product, which is protected by a patent, not only Europe, but also in Latin American countries, using a brand consistent in his name because he's a well-known cook in those countries. He first filed an European trademark application in May 2019, and later on, in November of last year, he filed an international trademark application claiming priority and designating, among others, Mexico, Colombia, Cuba, and Brazil. I just want to explain the main advantages for these Spanish cooks using this system. First of all, it was very cheap. He saved more than 50% in official and professional fees. And second, at the time of record a license agreement with his distributor in Latin America, which is going to be only one for all the countries, he only needs to file one recorder before WIPO and not going through the different offices. Just two different and very simple points that should show us the consequences of using this system.
So thank you to the speakers, and now we will launch our second and final poll question. We will comment the results, and then we will go into the takeaway message. So now it's for the attendees. Do you think that the Madrid system is the way to register your trademark in multiple countries? Yes, no, depends. So the poll is open, and you can now vote for your favorite option. So I see that many of you have voted. You still have, let's say, 10 seconds to express your preference, and then we will show the results and comment it. Okay, the poll is now closed. We're going to show the results. And apparently a vast majority has been convinced by our speakers that it really depends if the Madrid system is the best option for you. So I will call Ali and Simon to comment this result before we move on to the conclusion.
Well, I think that C is the right answer. As Simon already told, it depends on where you want to protect your trademark. You have to have a good knowledge of the trademark system in each national countries you want to protect your trademark, because I think he gave us the case of Cambodia, in which in 6 months you have your trademark registered. In Latin American, it's more or less the same. On the contrary, for example, in Brazil, sometimes a trademark lasts 2 or 3 years in order to be granted. So in this case, it's advisable to use the Madrid system. All in all, it depends.
Absolutely, I agree with you, Ellie. It's going to depend on the circumstances for each person, and some will find it right not to use the system for their own particular reasons, but the majority will find that it depends on the circumstances for their registration. So I think that's a good reflection.
I think we can move on to the takeaway message now.
Great, thank you, Marta. Well, allow me to offer a couple of takeaway points. Perhaps the first is that the most important thing is be first to file your registration. Ideally, aim to register your trademark before you go. You've heard the trademark regimes in China and Southeast Asia are generally first to file systems. So that means the first person to file a trademark application will own that right in that country once the registration is granted. So if you don't apply for protection on time, others may do so first and benefit from your investments and reputation. The best practice is, if you can, register before you go. Never allow your supplier or subcontractor or agent to register a trademark on your behalf. Many have done so because it seemed convenient, but it's not. It simply means that you've given ownership of your trademark to someone else in those countries. It's best to choose a local word or character mark for markets where Roman characters are not predominant. This can prevent unwanted registrations and prepare the way for sales in the country of your interest at a future date. So do consider the relevant translation of your trademark carefully and enlist the help of native speakers and marketing experts where you can. And lastly, do make use of professional help. Get the advice of a local lawyer or trademark agent to ensure you are adequately protected in relevant classes. Don't just consider the immediate class for the product to be sold, but consider whether the same trademark could be used on related items or services, such as packaging, advertising, or merchandising. So I know Ellie has some more tips for you. So over to you, Ellie.
Thank you, Simon. Yeah, well, regarding filing strategies, I think that the applicant will get the most out of the Madrid Protocol if he chooses to use it for a trademark that will not encounter problems during examination in most of the contracting parties. The selected word, name, symbol, or device must be capable of distinguishing the owner's goods or services from the goods and/or services of others to avoid any kind of observations issued by the national offices or oppositions filed by third parties. Also, and this is for European companies, using an European trademark application or registration as the basic application or registration increases the risk of central attack during the 5-year dependency period. This is because oppositions and cancellations can be raised by third parties on the basis of prior rights in any of the member countries of the European Union. So sometimes it is advisable to use as a basic mark a national trademark. Well, in the case of Latin America, it's clear that we need to expand the system to other countries. It's quite rare that we only have 4 countries member of this system. And very important, once you obtain trademark protection in the designated countries, don't forget to use the trademark for the classes protected, just in order to avoid the risk of cancellation due to the lack of use.
So I think we are ready for the question time. Now I will read out loud the question that we receive. So I invite all the attendees that have not done so to submit their questions. Meanwhile, I will start with one of the questions that says, how do you suggest we choose a Chinese version of our trademark? So I think this is a question for Simon. It's about the Chinese version of the trademark.
Okay, thank you, Marta. There are basically 3 ways to choose a trademark, a Chinese trademark name, and you can generally apply this process to other languages too. The 3 choices are: you can create a literal translation. So, for example, if a trademark has a distinctive meaning, for example, Apple computers, Apple chose 苹果, which is the Chinese for apple. Then that can be a great way to come up with a Chinese version of your trademark. But be aware that the literally translated trademark will be pronounced differently to the European equivalent. So the reputation of that mark will have to be rebuilt in China. But the second way is to create a phonetic translation so that the trademark sounds the same. McDonald's has done this in China. They chose the name Mai Dang Lao, which sounds like McDonald's to Chinese consumers. The European company Siemens goes by the name of Siemens, and the car company Audi is known as Audi in Chinese, and these names phonetically sound just like the European trademark to the Chinese consumers. And this is probably the best option for trademarks which are already famous in China. But you have to be careful with phonetic translations because the Chinese version could have an undesirable meaning. So what's the very best option? Well, the best option is the third way, which is to try and combine a literal and a phonetic translation to cover your trademark in that language. And clearly you're going to need some language assistance to be able to do that. So those are the three ways that you could use to try and choose a Chinese version of your trademark.
Okay, thank you, Simon. It's very, very interesting and complete answer. So we have another question that asks how I calculate international application fee and make a payment to WIPO. I think maybe Ellie can answer this.
Yes, well, the fees payable in connection with an application for international registration comprise a basic fee, then a complementary fee for each contracting party designated, and a supplementary fee for each class of goods and services in excess of 3. You have to consider that for certain contracting parties, the complementary fee is replaced by an individual fee. To confirm whether or not a contracting party applies the individual fee, you have to check the WIPO website. And regarding the last part of the questions, you can pay by bank transfers and also with a credit card.
Okay, very interesting. I didn't know the second part. There is a question about Southeast Asia that says we want to register our wordmark and logo. Should we register them separately or combine it as one? Is regarding Southeast Asia, so I think Simon will answer.
Okay, thank you, Marta. Well, as a general rule of thumb, the trade name should be protected first. I think you should protect the part of your branding that can be more easily spread by word of mouth, rather than a symbol or logo that cannot be so easily articulated in spoken language. It is possible to register both at the same time in one single registration, and that's called a composite mark. But for reasons I'll explain, this is not ideal. Separate registrations reduce the risk of objection, as the application for a composite mark could be rejected because, for example, the logo element bears similarity to a prior mark when there are no objections to the name element. Another reason to avoid applying to register a composite mark is that if there's an infringement where only the trade name portion is taken by another party, the infringing party may have an arguable defense. Strictly speaking, the registration comprises of two elements, word and logo design, whereas the other party may have only taken one element of the registration, the word element. The usual test for trademark infringement is whether there's a similarity when compared as a whole between the infringer's use of the trade name and the composite mark as registered. So in practice, courts may take a more robust attitude and rule against the infringer, but such a position is not necessarily certain, and composite marks should therefore be avoided. And just add that there is another option worth considering, and that is to protect your logo under copyright law, which generally does not need registration. So it's important when designing your logo to avoid any doubt and specify in your contract with the logo designer that you own the copyright of the logo. There've been many cases where failing to get this rather simple paperwork, the true owner of the logo doesn't have the necessary documents to enforce their rights. So the option of using copyright law to protect a logo, while it's a useful fallback, is not entirely established. So if this is something you are contemplating doing, it is worth seeking professional advice beforehand.
Thank you, Simon. Yeah, we always recommend, alongside with the professional help, also the idea of overlapping different kind of IP protection for a better overall protection. So we go with the last question, which is, how can I transfer my international registration to someone else? I hope that Ellie can answer this, maybe.
Well, yes, Marta, the request for the recording of a change in ownership of an international registration must be presented to WIPO on a form. I think that is the form MM5, either directly by the holder or the representative. You have to consider that you have to pay the fee for recording this change in the ownership, which is 175 Swiss francs. And one thing that is very, very important is that you should be aware that the new owner has been also entitled to be the owner of an international trademark. That means that the new owner should be a national or with address or with an industrial or commercial establishment in one of the contracting parties.
Thank you, Ali. I just see that we received 2 more questions. Actually, I thought we have finished, but if you don't mind, there is one question regarding China. What's the best course of action if you discover that your trademark has already been registered in China? It's better to wait for the 5 years of no news to pass, or to do a different option, example, registering the literal translation if the fake registration uses the phonetic translation, or vice versa. So Simon, can you answer this? Is clear?
Yes, certainly. Thank you, Marta. Yes, and unfortunately, this does happen from time to time. So your options are limited, but waiting for a revocation through non-use is certainly one method of recovering the trademark. If you can wait that long, you only have 2 other options. One is to to initiate a bad faith action, and which is difficult because you do require rather a lot of evidence to be able to persuade the authorities that the other registration was made in bad faith. So that can be challenging. And the other option is, of course, to try to buy the trademark back from who has ever registered it as perhaps a faster means of getting the trademark back. So none of those 3 options are particularly easy, but it's going to depend on the particular circumstances of that case as to which would be the best.
Okay, and we have another question still on China that asks, what should the company do in case if you have registered your trademark in both English and Chinese, for example, but your competitor has registered in Chinese how the mark sound. So basically, someone has a registration in Chinese and English, and the other one has a phonetic translation. Which is the best option to take all this phonetic translation?
Yes, thank you, Marta. Yes. Well, again, you're in a sense in a similar situation. You would have to try to initiate a revocation or cancellation proceeding if, depending on the particular circumstances of the case and how similar the marks actually are phonetically, and also whether you're talking about a registration in exactly the same class and subclass. So it's possible that you may have grounds to apply to have the other mark cancelled, but it would not necessarily be easy to do, and you would have to look carefully at the specific circumstances of that case. So without knowing the details, I think you are likely to need some professional advice on that in order to move forward.
Thank you, Simon. And with this, we completed our webinar. I want to thank you all the attendees to stay with us today. And I want to profusely apologize for the problem with the Wi-Fi. I hope that it was easy to follow anyway, despite our technical problems. And I want to thank you once more, our two speakers, to present to us today. So thank you to Simon, thank you, Heli, and I'm looking forward to cooperate with you in the future again, and to see all the attendees to our next webinar, for example. Thank you and goodbye.
Thank you. Bye-bye.
Bye.
Thank you.
Thank you.